Participants are in listen-only mode.
Good afternoon, everyone. I'm Jeremy Streten here with Craig Mason, and thank you for attending our fourth webinar in our Accounting Partnership Plus program, and this one's in relation to engaging with clients and debt collection. For all the people who have been here before, welcome back, and for any new attendees, thank you for coming along, and we hope that we can provide some information that's of interest to you in relation to these topics. Please feel free as we're going to answer any ask any questions that you might have. Craig and I are happy to answer questions as we go, although there'll be an opportunity at the end to also ask questions. In the chat box, I'm going to share a Dropbox link as I normally do. It's going through now. That's a link to a Dropbox folder that has a copy of the slides and a free gift that we're giving to everyone who attends the seminar today, and Craig will talk about that later on. So what we're talking about today, engaging with clients and debt collection, is a very important topic for business owners. It's something that people get wrong a lot of the time, and we're going to talk about really four main topics. The first one is the actual engagement with client process, and we're going to talk about that in the sense of you guys as accountants and also for your clients. I'm also going to talk about terms and conditions. So we do a lot of reviews of terms and conditions, and what we're going to talk about in that section is some of the things that we see should be in terms and conditions and a few that are often not, and you'd be surprised as to which ones often aren't in terms and conditions, but that's why we're going to do the talk. Craig is then going to do a talk about the personal guarantees, and then he's going to talk about debt collection. As I said before, please feel free to ask questions as we go, and we're happy to answer them, or as I leave them to the end. So just before we get started, I wanted to just make you all aware of the business legal life cycle. This is some intellectual property that Craig and I have put together in relation to a business and when you should do things from a legal point of view. I've actually written a book on this, which has been released in June, and basically what it is it's explaining to people in plain English legal processes, and it's a handbook for new and existing business owners about when they should do things in business and help them to build a successful business. The reason that I'm raising it today in the webinar is just to show you where this topic fits in the business legal life cycle. So in all our webinars and seminars from now on, we're going to be providing this slide and showing people where this falls into the business so that people have an idea about where their clients and where their business should be up to in the business legal life cycle and the topic that we're talking about. If anyone's got any more questions about business legal life cycle, I'm happy to take questions on that as well as this topic, and also I'm happy to take emails and other correspondence in the future if you've got any questions. So engaging with clients. As I said earlier, engaging with clients is something, and it's part of a business that many of us get wrong. We're not perfect at it. We know many of our clients aren't perfect at it. In fact, I'd imagine that probably all businesses do this incorrectly in some respects. What we see with especially professionals like us lawyers and you guys as accountants is that we often start working with a client. You set up multiple entities, and then you don't have any proper engagement process to bind those entities in together. So after I talk about what should go into a proper engagement letter for clients, I'm going to talk about change orders and their importance, especially for professionals where we're setting up entities, because it's great that we set up these great asset protection structures, but that can end up coming back and biting us if we haven't engaged the client properly and the client refuses to pay. So first of all, I'm going to start with the engagement letter. So what I'm going to go through here, again, the things that we see as necessary in an engagement letter, and some of them you'd be surprised that people get wrong or don't do. So the first one is who the client is. So it's really important to properly define the client. It's not just good enough to say Joe Bloggs and all his related entities. You need to list all of the entities and have them all sign to say that they're bound by the engagement. The same goes for your clients. If you've got a builder and they only engage, say, one owner of the property and not both, then only one owner is bound to the contract. So again, it may sound really simple, but getting that right is really important. It's also the other thing that we see quite often wrong with defining who the client is not putting the right entity down. So if Joe Bloggs is trustee for the Bloggs Family Trust, you want to have that full title in there because the trustee is the one who's primarily liable. I talked about that I think it was webinar 2 about structures and the like, if you're going to engage with a trust, you need to make sure that you list the trustee so that the trustee is bound. If you don't list the trustee, it can be very difficult because, as we know, there's no public register of trust documents to know who's actually liable for the debt that you incur. Another one that you'll be surprised that people get wrong is not defining who you are, so who the person is who's actually engaging the services. So a great example of this is, and it came back when we were preparing this webinar a month or so ago, we got engaged by a storage shed company. Had this great storage shed agreement that they paid thousands of dollars with a professional to prepare. The problem with it was it didn't define who they were. So you had a contract that didn't properly define who the parties were. This one didn't even have the address of the storage shed facility, and so what that meant was it was pretty hard to enforce it because there was a great deal of uncertainty as to the subject matter of the actual contract. So defining who you are is very important to have somewhere in your engagement letter, and the same applies for your clients. Defining that it's Blogs Construction Services Proprietary Limited just gives that certainty as to who the client's actually engaging with. Defining the scope of the work that you're doing. Now, this comes down to, it becomes more important when you're quoting fixed fees. So if you're doing a fixed fee rather than a time estimate, defining the scope of work that you're doing for that fixed fee is very important. And the reason for that is that the last thing you want is for a client to get confused as to the work that you're actually doing, or for you to get confused or not understand what the client wants. If you define in good detail the actual scope of the work that you're doing, then the client will not have that problem. You will not have the problem of the client coming and saying, but I thought you were going to do X, Y, and Z. And the same applies for time costing too. We personally don't do time costing. We do fixed fees for all our work, but in past lives and in working for other lawyers, we charge time. And one of the greatest problems that I saw with time was if you gave a quote, say you're going to do a business purchase and you quote the client, we're going to charge you on time, but it's going to cost $2,000. And then there's all this additional work and the client's charged $4,000. The client's not happy about that. They never are. They never are. And the problem with that is, just from a client relations point of view, it's good to actually properly define all the scope of the work that you're doing. And the other reason for that too is from a liability perspective. So if you're being engaged by a client and the client thinks that you're going to prepare all this work and you don't think you are, if you haven't properly defined what that scope of work is, then the client might rightly have a complaint to say that you haven't done something that you might need to do under the contract of engagement. So defining that is really important. The next one that we see wrong so often are conditions precedent. So conditions precedent are the things that you need before you will start doing the work on the file for the client. The classic example for you guys as accountants that we see all the time is the payment of money up front or the provision of documents. Properly writing down and defining what the client has to provide before you start work is really important, because what we see happen, and it happens with lawyers too, we're not saying that accountants are the only ones who get this wrong, is that the clients think, well, I've given them ABC documents, when the accountants think, well, I'm not going to start until I get ABC and XYZ documents, and then the client comes back in a month's time and says, where's that work that you were doing? And then they're sitting there going, well, why didn't you tell me that you weren't going to start doing the work until you provide all that information? If you set that out clearly in an agreement, then there can be no doubt as to what was agreed to, and the client will have to comply with that requirement. Having comprehensive terms and conditions, which as I said, I'll talk about later or next, is really important as well. So I said at the beginning of this slide that I was going to talk about change orders. So this is where, and this probably mainly applies for you guys as accountants, and I'll speak to that in that situation, but it can also apply to your clients. If you've got a client that you've done lots of work for over the years, and you might have an engagement letter with, say, 3 or 4 of their entities, and then for asset protection reasons, you set up another 2 or 3, if you do that and you can't, and you don't engage the client so that all of their entities are all equally liable together, then you have to take a scattergun approach when going through the debt collection process. I should say too that what we're talking about here is the worst case scenario. So a lot of people, and we get this because we think it as well sometimes, a lot of people think, oh, well, it's okay, the client, my clients pay my bills. we're talking about the 1 in every 100, the 1 in every 1,000 client who doesn't pay their bills, and we're talking about setting up your documentation right so that that doesn't get lost along the way and that it becomes easy for you to collect the money if you need to in the future. And so the change order is exactly that. So you have this great client who's paying all these fees, and then all of a sudden they stop paying, and you've got a scattergun approach going after all these entities. If you have the right sort of change order, you can avoid that, because what you can do is you can bind the new entity and the old entities together to actually be all liable for the same costs and for the same, because you really want the person behind it. So, with the Joe Bloggs scenario I said before, you want Joe Bloggs to be liable for everyone, so that if you only have to sue Joe Bloggs if in the case that he doesn't pay for any of his entities, because at the end of the day, people want to avoid going bankrupt most of all, and that's why we set up all these great asset protection structures. The other reason for change orders is, especially if you're doing fixed fees. So if the client comes to you and says, and you've properly defined your scope of work in your initial engagement, and the client says to you, I want you to do all this additional work, you might say to the client, well, that's going to cost this amount of money. Properly documenting that is just as important as properly engaging them at the beginning, because you're defining what you're doing and what they're paying for it. So keep that in mind, and it's all about, most of it's about client relations, but also it's about protecting yourself for the future if you have a troublesome client. So the second part I'm going to talk about are terms and conditions. And I'm going to talk about two different topics. The first one are the things that we see as must-haves in terms and conditions, and I'm going to go through some of those to give you a bit of an idea about what we see as important for you and for your clients. And the other one is a couple of recent changes. They're a few years old now, but they're things that we're still seeing wrong in terms and conditions. So just to give you an idea, we review probably 2 or 3 terms and conditions a week, and the things that we're going to go through today may seem quite basic, but they're things that we see wrong quite regularly. So first of all, for any kind of business where there's multiple employees, who's going to do the work for you? If you don't define who the work's going to be, then often from a client relations point of view, they may think, well, I thought that the partner was going to handle the work, or I thought that XYZ was going to handle the work. If you properly define who's actually going to do the work, then that can greatly help to reduce any stress there. Equally, if you've decided that you want to do any offshoring or provide any offshore work, you need to disclose that you are doing that and obtain informed consent. So it's a good idea to have something in your terms and conditions, even if you're thinking about it in the future, so that clients are given that information up front. The second thing that's important is when the work is going to be done by. Now, this is not only from a client relations point of view, but also from a legal point of view. So from a client relations point of view, we all know that we want clients to know when they're going to get their work done. Clients want to know all their work and when it's going to be done by. And also from a liability point of view, we're all coming up to the date when all the tax returns are due. And the last thing you want to do is get documentation today from a client and engaging with the client and them expecting you doing it in 4 days or 3 days or however many days there is. So that's pretty important. The next thing is how any changes to the work or the scope of work are going to be performed. So that's the change order. So properly defining a process for the change order is pretty important to have right. The next one is how the agreement can be terminated. So we've all had that problem client who doesn't pay the bill, they don't provide information, or they go into liquidation, or something occurs. You need to have the proper definition of default and your termination rights that allow you to get out of the contract, because whilst it's unlikely, there's arguments that can be raised by a client to say, well, you were still engaged even though you haven't been paid to do this work. So from just a pure negligence point of view, it's a good idea to be able to terminate the agreement so that you can't have any problems in the future. The next one would be clients' rights and obligations. That's pretty straightforward, but this is where any of the client's rights to anything in relation to the contract or any of the obligations. So things like I talked about before, providing documents and matters like that. Interest is an interesting one. So if you want to charge interest on late payments, you need to have that defined in your agreement, unless you go to the court process, and Craig will talk about that later. But say if you want to have a 5% penalty interest rate if someone doesn't pay your bill, they have to agree to that at the beginning. It's not good enough to put that on an invoice. It's not good enough to just charge that, although you could try to charge it and see what they say. We've had that question a few times. And the same applies for if you want to get a a fee for chasing up a bill. So if a lot of people put on their invoices that there might be a $110 fee for every time you have to chase up the bill. If the client hasn't agreed to that, then you can't bill it. So what you need to do is you need to make sure that the client is aware that you're going to charge those fees and that they consent to the payment in any terms and conditions. That's something that we see a lot of clients coming to us and saying, oh, I want to charge interest, this is unfair. Well, unless they actually start proceedings, then they can't do it if it's not in their agreement. Client ownership of files and intellectual property. Properly defining who owns what in a file is really, really, really important, so that you know what you own and what they own. A lot of your file is owned by you because most of the things that you create are yours. But they're defining who owns what and what's going to be done with those files, destruction of files, those kind of things. Getting the client's consent to the destruction of any of their documents is very important. Confidentiality, we're all under obligations of confidentiality, but say for your clients, if they want to make sure that people don't go talking about the different types of work and advice they do, then confidentiality, a properly drafted confidentiality clause will give them that protection. Caveatable interest. This is the other one that we see people come to us all the time. They come to us and they say, such and such owns property, I want to go and put a caveat on their property. If they don't have a caveatable interest, then they can't lodge a caveat over the property. Now, what is a caveatable interest? A caveatable interest is something that is in a document and that charges any real property that the person owns with the payment of the debt. Now, it's a 2 or 3 sentence clause that goes into a lot of terms and conditions, and you might have seen them in your client's terms and conditions and personal guarantees that they sign with suppliers. But what it lets you do is it lets you go and put a caveat on the property for any debt that you're owed. Now, that has 2 effects. One, you can usually the bank will find out about it because the bank is notified of any caveat that's lodged over the property. It's a default of their mortgage, and the bank will most of the time force the person to pay the debt. The other thing is you've got 3 months from when you put a caveat on to commence proceedings, and you can actually, if you're owed enough money and it's commercial, get an order to sell the property to repay your debt. So it's a great advantage and a great tool that you can use for that really problematic client that you want to that you need to go after because you've done all this work for them and they haven't paid. Now, I have a question here. Is it possible at the outset to expand the definition of who you are engaging with to contemplate a wide range of future entities that are later brought into the structure, say much in the same way as a trustee does? Thanks for the question, and it's a good question. The short answer is no, and the problem is with that kind of approach is that those entities in the future haven't actually engaged with you to do the work. So they've got to properly engage with you to actually do the work. If they haven't done that, then you cannot bind them into that agreement. So having a broad clause like in a trustee, that doesn't work. See, a trustee works differently. It's set up so that whoever falls within the definition of beneficiaries at the time receives a benefit. Here, you're trying to bind in various entities to be liable to pay a debt. And to be liable to pay a debt, you've either got to show that they've agreed to pay the debt or that they're somehow otherwise bound. And that can be difficult if you don't properly define it. So I hope I answered that question. If you've got any other questions or if I haven't answered that specifically, please let me know and I'll see if I can expand on that further. So just in relation to the 2 legislative changes that came in that we see as problems in a lot of terms and conditions, I'll speak about these briefly. The first one is the Privacy Act. So the Privacy Act, it's been around for a number of years now, but in 2014 they made a lot of changes to the Act. Now, the changes to the Act changed a lot for businesses that the national privacy principles applied to. So the national privacy principles, put simply, apply to businesses with a turnover over $3 million a year, or if you're a business that's trading in personal information. So when we say trading in personal information, we're talking about someone who might collect information from third-party clients and then sell that information on. If you've got clients that are doing that, it wouldn't really apply to you guys, but if you had clients who were doing that, then that would be who we're talking about. So a bunch of those privacy principles changed, and additional obligations went into these national privacy principles. And if you've got any clients that you think that might apply to, it'll be good for them to go and get advice on that point just to make sure they're complying with those principles. However, in the 2014 changes, a number of sections in the Act were changed. Now, a lot of people have Privacy Act forms or terms and conditions that allow them to go and do credit checks on their clients. What we've found is that a lot of those clauses that provide the power to go and do those credit checks are not right. If they're not right, then actually going and doing those checks and doing inquiries may not be legal, and that can cause problems. It's probably just a matter of changing the clauses. But if if you know of anyone, or if you yourselves have got any Privacy Act forms or changes, then it'd be a good idea to get that reviewed just to make sure that they're up to date. Because as I said earlier, we review 2 or 3 of these a week, and they're almost wrong every single time. So that's really important. The second change, and this one has been around for a number of years, but again, we see it wrong all the time, is the Personal Property Security Register. So most of you are probably aware of what the PPSR is. It's basically a register that gives you a right and security over someone's personal assets. It's like putting a caveat or a mortgage over someone's house, but you put it over their personal property. If you or any of your clients engage in a business where they want to take security, so for instance, if they're a supplier and they want to take security over all of the assets of a company, or the assets that have been bought, say material from a supplier, then they need to lodge a PPSR charge. The law on this changes pretty regularly, and it's important to make sure that if you are doing that regularly, that you're complying with the law and that all the changes are properly documented in the PPSR clause, because there's clauses which basically charge the person's personal property. If they're wrong, then that could end up causing the person who's trying to enforce the debt more trouble, because what the Personal Property Security Register lets you do is go in and actually take personal property, sell that personal property to recoup the payment of your debt. It's not as, I put it very simply, it's not quite as simple as that, but that's what it basically lets you do. So that's what I've got to talk about the recent changes in terms and conditions. If anyone's got any questions, let me know now, other than the person I've already answered the question for. Otherwise, you can hold them to the end. And otherwise, I'll hand over to Craig.
Excellent. Thanks, Jeremy. Good afternoon, everyone. As Jeremy said, I'm going to talk about personal guarantees, then move on to the debt collection process. So personal guarantees, most of us would have signed one in the past. If you ever got a loan from a bank or anything like that, then you're normally personally guaranteeing the debt, particularly if a company's involved. So it's a second recourse that ultimately might be the only recourse. If your client is a company and something happens to that company, they're going to liquidation, for instance, then your only recourse in that instance may be pursuant to a guarantee. So it becomes quite an important document to have. In your instance, dealing with your clients, as Jeremy said, your engagement should be ultimately with the individual, as well as any structures or companies, trusts and whatnot that you set up. So in that instance, a personal guarantee hopefully won't be relevant, but you can include it, and it's particularly relevant for your clients that you're talking to. As a trusted advisor, when they contact you and talk to you about these sorts of things, where they've been done over by a company that's gone into liquidation, then that's the time that personal guarantees need to be spoken about and incorporated into businesses' documents. So if a company is in administration, the personal guarantee cannot be pursued during that period, but if the company goes into liquidation from that, then you can, and provided the personal guarantee is drafted properly in the first place, then there's no obligation to pursue the company first. You can go straight up to the guarantor if there's an outstanding debt. So it's obviously an important document. It's not a copy and paste situation where you steal someone else's and use it as your own. It needs to be drafted properly and needs to include a variety of clauses. So one of those is that, again, it's got a charging clause in it, the same as what Jeremy said in the terms and conditions. So it's a charging clause where the guarantor charges their real property. So you can, again, lodge a caveat over their property and pursue the guarantor through that process. It should be a continuing guarantee. It should bind the successors and the legal personal representatives, so the estate. If there's more than one person that's signing it, then obviously it should be joint and several between those parties. Most of the time it's obviously the directors of the company, but the terminology's changed somewhat recently, and it's always called a personal guarantee, not called a director's guarantee. So it doesn't have to be a director of the company. It can be someone else that's willing to sign it. And the other thing to consider as well is that there are certain clauses floating around that try to sort of circumvent the personal guarantee actual signing of it. Something to mention to your clients if you're ever talking to them about it, that some businesses are incorporating a clause into their credit applications that basically says that if the person that signs the credit application also is a shareholder of the company and owns more than 15% of those shares, that they're automatically guaranteeing or personally guaranteeing the debt. So it's a sneaky clause that obviously a lot of businesses incorporate because it gives them that second opportunity. If the personal guarantee is not signed for whatever reason, then they can rely on that clause. To our knowledge, it hasn't been tested in a court, as in a magistrate hasn't made a decision or a judge hasn't made a decision, but it's definitely something that can be used if you get to that point where you need to sue someone. So all these sorts of things that we're talking about are, as Jeremy said, worst case scenario things. But if you have everything in place and it's personal guarantees, the ability to charge interest, those sorts of things, it gives you that opportunity to increase the debt. So it might have only been 500, but now you're increasing it to whatever the interest is and those sorts of things. It all adds up as compensation for the non-payment of the debt, and it also gives you the opportunity to include individuals, which, as we know, are more likely to have property rather than a company. The flip side to all of this is that we see a lot of businesses signing personal guarantees. They've got suppliers all over the place. They've signed guarantees. They don't keep a record of which ones they've signed, which ones they haven't. So there is one question. I'll just finish off on this and then I'll get to that, is keep a track of it, because in the instance that you're facing financial difficulties and you need to start paying back creditors, the ones to pay back first potentially are going to be the ones that personal guarantees are signed on. The reason for that obviously is that if your company does go into liquidation, then the personal guarantees are going to be live and you are going to get chased individually. But if you pay back the ones that you sign personal guarantees for, then obviously they go away. There could be potential preference payments, but that's not really your problem. That's theirs. So it's something to bear in mind, that if you keep track of all these sorts of things, then you may need to use it down the track. So it's probably good practice in any event to know exactly what you're dealing with. So we've got a question here. Have a client, a group of companies refused to pay. It's about 6,000. One company's gone to liquidation, has signed the engagement letter and personally guaranteed the fee. How successful is legal action and how difficult is it to get funds once a judgment? I think the house, etc., is in the director's wife's name. Can I pursue the director personally, and is it worthwhile to pursue legally? Excellent question. And I guess it's the old legal lawyer answer, and it depends. We'd have to have a look at it, but I'll explain. Once I finish with personal guarantees, I'm going to go quickly into the debt collection process that we follow, and then I'm going to go through the court process, and I think most of your questions within that are going to be answered in that section. So if you've still got questions about it at the end after I explain that, then let me know. All right, so that's personal guarantees. The next thing, as I said, is the debt recovery process. So in our business we have a process, and it's important to follow that. We say it shouldn't be a case-by-case thing. It all goes into all invoices go into this system, and that eliminates any missing invoices. There are, of course, always going to be things where there might be a payment arrangement that's been entered into with one of the directors, or some reason the invoice shouldn't be chased up in the ordinary course. So there are provisions in that. So Jeremy's shared the Dropbox link, and within that is our free gift for today's webinar, which is the debt recovery process. We invite
We'll just share it. Sorry, Jeremy here. We'll just share it again because I think there's a few people who've logged on since we actually shared that to begin with. Oh, no, it's gone through twice. There you go. There's the Dropbox link for everyone.
Okay, so in there is the debt recovery process, and we invite you to peruse it and to incorporate it into your business or give it out to your clients. But essentially, it's the process that, as I said, all of our invoices go into. So once an invoice is issued, it goes to the relevant person, obviously the client, and depending on your terms, whether it's 7 or 14 or 21, it then goes into this process where there's timing. So in our instance, where our terms are 7 days, so after 7 days, on the 8th day, a friendly reminder is sent. These sorts of things happen, etc., etc. Here's a copy of the invoice. Here's our bank account details. Please pay. There's a template for that within this process that we've provided. Then, if the invoice still remains outstanding, it's now 14 days in our instance since we've sent the invoice, so it's a further 7 days overdue. We send another email, which is called our overdue email template. That's, we're less friendly than the first one. Please pay, make sure you do it, etc., etc. Again, bank account details provided, those sorts of things. There's then a reminder for the next step, which is the final notice. That's now 21 days invoice overdue, so 28 days since we've sent the invoice. And that's the final sort of email where, we're no longer friends, blah, 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 please pay. Then the next step, and this is one of the important ones, is the direct contact. So in our instance, our invoice is 45 days overdue and 38 days since we've sent the invoice. So this is normally a telephone call. So we've got a script there. The most important thing in this particular direct contact stage is to be prepared for that telephone call. So have all the invoices, have the file, have all those sorts of things ready. It mightn't be the best idea to have the file handler making these calls. It should just be an accounts receivable section. But if they've got everything ready and you are speaking to the debtor, and the normal sort of excuse at this point is, I never got the invoice, can you please send it to me? If you can send it right there and then, you've got Neville sitting on the telephone call and you say, all right, Neville, you're sitting in front of the computer, yep, and you send the invoice right there and then you don't have any issues where you've then got to contact them later on. So if you don't resolve it there on the telephone and it's back on you to have to do something, and email, etc., etc., there's a rough chance that they won't answer the telephone call the next time around. They've got your number, they'll remember it now, and they may start avoiding calls. Not always, but if their intention is not to pay the debt, then that's definitely going to be the time they're going to do it. So again, if you don't get any joy out of the direct contact stage, then in our instance we issue what's called a formal letter of demand. It's now 53 days overdue, 60 days since we've sent it, and that is, we're going to proceed with legal proceedings. The importance of that letter is that it says, that there are going to be costs involved, those sorts of things, legal costs. It's important to notify the debtor that is going to happen. Then if you do proceed with legal proceedings, there's no issue later where they say, oh, you did that prematurely, I'm not going to pay your legal fees. You've outlined that in the formal letter of demand, and obviously that argument goes out the window. You've said to them, if you don't pay by this particular day, then legal fees are going to be incurred and you're going to be responsible for them. So that eliminates that argument. So that's an important final step in the debt recovery process. So as I said, have a look at that document. All the template things are already in there, and we invite you to use that as our free gift for today. Now, obviously all those things happen, but you still don't get paid. So in that instance, I'll go through the debt collection through the court or the tribunal process, which I think will answer the previous question about personal guarantees and whether or not and what you can do with the judgment. So basically you've got two options when it comes to court proceedings. So you've got what's called the Queensland Civil and Administrative Tribunal, which is called QCAT. Now that's for debts that are less than $25,000. It replaced the old minor debt court or tribunal. In that tribunal there are no legal fees, and in most instances legal representatives are unable to appear, so you're on your own. You file your application which says, Never owes me $5,000. You pay your filing fee, which is about $200, and then needs to be served. If Neville defends it, it goes to a mediation pretty quickly and a trial. But all of those things are the individuals by themselves without any legal representation. You can speak to a lawyer obviously outside of that and get advice, but that lawyer is unable to appear, and those fees that you may have paid that lawyer are unable to be recovered as part of the debt. In the end, if you do or are successful in QCAT, you get a shiny piece of paper that says that Neville owes you $5,000. With that piece of paper, unfortunately, you then need to enforce that, and in order to enforce it, you need to register it in the particular magistrate's court. We're talking about Queensland here, but you say the debt has moved to a different state, you can register it in a different state's jurisdiction. But in Queensland, you register in the Queensland Magistrates Court, and then you need to enforce it in the Magistrates Court. So our advice is, and not just because we can charge legal fees, but is to start proceedings in the Magistrates Court in the first place. The reason for that is you can recover the legal costs that you incurred, so they automatically get added on. So for instance, if you're owed $5,010, the legal fees for that would be $825, which automatically gets added onto the debt. There's a filing fee of $219.80, and that automatically gets added onto the debt. So instead of $5,010, it's now $6,000 and something. As Jeremy said, if you don't have interest in your terms and conditions, you can charge interest at this point from the date of the debt. At the moment, the court rate is 6%, so you add that on, and now the debt's up to above 6.5%. So all the costs and interests are all included. This is all through what's called a claim and statement of claim, which is essentially the claim is the details of the debtor, and the statement of claim is the story as to exactly what's happened. So that's a contract was entered on this day, services provided during these days, invoices were provided on these days, demands have been sent, etc., etc. It still remains unpaid. Once you file those documents, you then need to serve the documents. So if it's a company, then you can serve it on the registered office. In your instance, if it's a previous client of yours, then you may still be the registered office as the accountant. In that instance, obviously don't post a letter to yourself. It would theoretically be good service, but you can see the issues with that. So in that instance, you would need to serve the director personally or directors personally. In order to do that, you get a process server involved, and they go out there to the address and try to serve them personally. In Queensland, you can also leave the document with an adult over the age of 18 that apparently lives at the address. So, normally that's a husband and wife situation, so you might be trying to serve the wife, the husband's home, provided the husband's over 18, which would be normal, then you would be able to give it to the husband or the wife or the child or whoever it might be that's over the age of 18 and lives at the address. If, for instance, Neville is dodging service, jumping over the back fence or peering through the curtains and not opening the door, there is a process where you can do what's called substituted service. So you can make an application to the court to basically say that we can't serve the particular person for whatever reason it might be, but we know he owns that property. He gave this address when he signed up for our services. Here's his mobile number, the address on ASIC, all those sorts of things. And the court, if they're convinced that it's likely to come to their attention if you, for instance, post it to that address and then potentially text the person to say we posted the documents, or email or nail it to the front door, those sorts of things. So there are mechanisms in the court process that allows you to what's called substitute service on someone where ordinarily you need to personally serve the document. So once you've gone through that process, the defendant at this stage now has 28 days to file what's called a defence. Where a defence is basically a response to your statement of claim to say, I disagree with these things, etc., etc. If they do file a defence, then you're in the litigation process, and the court has certain rules about what happens. Eventually, it goes to a trial where a magistrate makes a decision. If they don't file a defence, then you can make an application for what's called default judgment, which is the same as QCAT, where you get an order that they pay you all this money. The difference between QCAT and the magistrate's court is, as I said before, it now has cost and interest added onto it. Once you get judgment, you can claim, or interest is still accruing at 8%. That also gets sent off to the defendants and goes on their credit file, so it affects them if they ever want to get a loan out or anything like that. And that's good for 12 years, the judgment, so you can enforce it during that period of time. So a lot of instances it might be that you do proceedings, get judgment, and then basically just sit on it. The amount of times that we see where someone then wants to get finance for whatever reason, and your judgment's there, and they contact and say, "Oh, look, I need to pay this to get rid of it." So that can be a tactic. It could be, you send them a letter before that as well to say, "Look, I've got judgment. Please pay, or I may take some further steps." So we call that a post-judgment demand. Obviously, now that you've got a judgment, and if you do want to enforce it, there are a variety of options that you have available to you. So this is probably going to answer the question about enforcing judgments. So there is what's called an enforcement warrant for seizure and sale of real property. So that's similar to a caveat, except it's called a writ on title. So you register a writ on their property. You can then instruct the bailiff to auction that property. In order to do that, the bailiff currently requires $2,500 to cover those fees to auction the property. It's then auctioned, and obviously, hopefully, you get paid from the proceeds of that. You can put the writ on the title and leave it there for a period of time too, so that eventually they may want to sell it, and then again they need to contact you in order to get that withdrawn. So that would be payment, obviously, at settlement. You do need to continue to renew that. It doesn't necessarily lapse like a caveat after 3 months where you can't put another one on there based on the same facts. A writ you can keep renewing. You just have to keep filing documents with the court every 6 months and then filing it again with the Department of Natural Resources. So it's a bit of a process, but it's nowhere near. It doesn't lapse like a caveat, so it's definitely an option. The other option is with a bailiff. Again, they can go out there and seize actual property. So it might be the golf clubs or the plasma television or whatever it might be. And again, they can sell those items in order to recover the debt that's owing. You can do what's called an enforcement hearing, where you bring in the defendant. If it's a company, then it's the director of the company, and they need to answer a Form 71 financial statement, which basically spells out their entire financial history dating back for 3 years. So it's pay slips, tax returns, bank statements, all those sorts of financial details, what their expenses are each month. From that, you can, if they're employed, garnish their wages. So it's a document that's served on the employer, and the employer then needs to deduct each week or pay cycle an amount of money that the court says is to be paid to you. If they are in fact owed money by someone and that is regularly paid to them, you can redirect that debt, and instead of going to your debtor, it goes to you. You can do a garnishee on a bank account. So you've got the bank account details there. You can then get a court order that ANZ or whoever it might be at the particular time if there's sufficient funds in there, draws a cheque in favour of you and sends it to you for the amount that's outstanding. So there are other ways to enforce a debt other than just if the debtor, if the debtor doesn't own any, like a house for instance, then there are other ways to enforce it that would probably answer the question that we had about whether it's worthwhile to pursue. So it'd probably be, if you've got judgment, potentially to start with an enforcement hearing. We've got another question here. If no clause to collect costs of collection, does that mean you cannot claim costs of magistrates court? The answer to that question is no, they're two separate things. So one is, normally when you talk about collection costs, that's about if you've got a debt collection agency involved. So they charge a commission. There are ways where you can add that to the debt, but there are provisions in the Act that governs debt collection agents that prohibits them from collecting that as a debt. But there are other ways around that. So that's separate. But if you institute legal proceedings, regardless of whether you've got it in your terms and conditions, you can claim the legal costs. But you have to obviously have a lawyer involved. So you can't claim legal costs for yourself, for instance. But if you have a lawyer involved, then there's a scale of costs the court determines are recoverable. So they're automatically recoverable. You still have to get it from the debtor, but if you're adding those costs on, they're your costs that you've incurred, and you should not be out of pocket if it's like that. So the other question is, can I sue a director personally? Well, I guess the answer to that again is it depends. If you've got a personal guarantee, then yes. If you've included the director, for instance, in your engagement, then again, you should be able to. Hopefully it binds everyone. It'd be a situation where we'd probably have to look at the original document that was signed. But if it's a simple matter that your client was a company, you don't have a personal guarantee, and there's no way that we can bind the director, then it's unlikely that you'll be able to proceed against a director. But if you've got all those other things in place, then yes, you can sue a director or an individual personally. So they're the enforcement options. There are, as a last resort, obviously, if you don't have any luck with that, then there is the bankruptcy and the winding up process. So in that instance, for a bankruptcy, so that's an individual debtor, the threshold for that now is $5,000. So you've got to be over, your judgment's got to be over $5,000. You then file what's called a bankruptcy notice with the Australian Financial Services Authority. The cost of that is $470 for the filing fee, plus professional fees, which in the industry is normally sort of around about the $400 mark. Again, you need to serve that document, and the debtor then has 21 days to pay that. Failing that, they've committed the act of bankruptcy, and you can then proceed with what's called a creditor's petition, where you ask the court for a sequestration order, where you appoint a trustee to the person's estate, and the bankruptcy process starts from there. So the issue with that at this point is you need to file that with the Federal Circuit Court, and the filing fee for a creditor's petition at the moment is $3,198, so quite expensive, plus the professional fees for that. So in order to bankrupt someone, you're probably looking at around the $7,500 mark, which includes all those outlays. Those costs are paid in priority. If there are funds in the bankruptcy, then they get paid equal first with the trustee. But your actual debt is unsecured and sits in with the pool with everyone else. The other for a company is obviously winding up or appointing a liquidator, and that's normally started with what's called a statutory demand. Similar to a bankruptcy notice, you don't file it with the court. In that instance, the threshold is $2,000 as a minimum debt owing. You serve the stat demand. Again, if it's you as the registered office, then don't post it yourself. You can or will have to personally serve that on a director. Then they have same time frame as a bankruptcy notice. They have 21 days to respond or make an application to set it aside if they say the amount's not outstanding or they are solvent or whatever reason it might be. If they don't do that, then again they're deemed to be insolvent, and you have 3 months from the expiration of that statutory demand to file your wind-up application in Queensland at the Supreme Court, or you can do it in the Federal Court. Again, the filing fee, it's cheaper in the Supreme Court, it's about $2,000, and it's up to $3,000 in the Federal Court. Again, your costs are paid in priority, but your debt is going to be unsecured. If it's a simple debt matter, it's going to be unsecured and it's going to sit in the pool with everyone else. So can be expensive. You've got to be owed sort of probably around the $15,000 mark, I think, in order to make that cost effective, and you particularly with bankruptcy, you probably only look at doing that if there was a property that the person owned. So that's the debt recovery, debt collection process. As we said, if you have all those things in place at the beginning, it makes the whole process a lot easier. It makes it a lot more cost effective. And if you've got interest clauses and cost collection clauses and admin fee clauses and all those sorts of things included, then they're all going to get added on to the debt and hopefully compensate you for your loss of time in that instance. So if there isn't any questions, I think I've answered the two that came through. Has anyone else got any questions? If something you think of later, then please feel free to email us. That's us and our email addresses. This webinar is being recorded as well, and we can put that up in the Dropbox later on for you to look at again if you feel the need. But if there's no other questions.
One other point I'll make just to before we finish up, in case there's anyone typing any questions as we go, there should be a questionnaire that pops up at the end of this webinar. So if you could please fill that out. We're always very keen to get your feedback, especially on topics. So we're currently starting to look at topics for the new financial year. Obviously, this quarter will be over in a month or so. If you've got any topics that have interest you, please let us know, because we want to tailor these to work for you guys. We want them to be things that are of interest to you and covering topics that you want. So please feel free to make any suggestions, and we'd be happy to cover any topics that are within our field of knowledge as lawyers who handle everything for small to medium-sized businesses. Doesn't look like there's any questions, Craig, so I'd like to thank everyone for attending. And as Craig said, there'll be the Dropbox link. We'll send that around again, and in there we'll throw in a video of today, just in case you want to reference any of it. And if you've got any questions, then please feel free to get in touch with us. Thanks very much for attending.
Thank you.